your investigation and being at the accident immediately after it happened, wouldn't you?
In some ways, yes. In other ways, no. In the ways in which I highlighted, no.
So is that a yes or a no to my question?
Well, in some ways, there was an advantage in the sense that you're there right as the accident happened. However, because of so many unknowns and the outdated formulas, they're at a disadvantage in determining speed. They're also at a disadvantage because there was no event record data to know the exact speed. They're disadvantaged there. There's so many unknowns.
Objection, Your Honor. Narrative.
Right.
Motion to strike, Your Honor.
Your Honor.
The motion strike is not granted. Just move on to the next question.
Now, Mr. Roman, I just want to clarify for you, just with a simple yes or no, Officer Foster had a significant advantage of being at the accident site immediately after it happened. Isn't that right?
It's true.
Now, Mr. Roman, you were hired by defense counsel to test the specific plausibility of a deer running in front of the road. Isn't that right?
That was one of the things that was identified. That's correct.
But earlier in your investigation, you came before us and you told us that your firm, Expert Accident Reconstruction, deals with finding the most likely cause of an accident. Isn't that right?
That's correct. In this case, I believe that with the invasive move of the car, as well as the dense population of deer in this area, this was the most likely cause.
Nowhere did you mention that you are approached to test specific scenarios of the deer, did you?
No, I wasn't hired to approach a specific scenario, but they also wanted me to consider this because Daniel Dawson said this was our kind of
Mr. Roman, is it your testimony today that you were not hired to test
Objection, Your
this?
Honor. I asked him I would be allowed to finish his answer.
Granted.
Yes, so the way our expert firm conducts any investigation is that we have our standard processes that we follow, and we take into consideration things that our clients would like us to consider, and we analyze them, and we get back to them and let them know this is plausible or implausible.
Mr. Roman, is it your testimony that you were not hired to test the specific scenario of a deer running in front of the vehicle that night?
Yes, a deer, but not solely a deer. That's correct.
So is it your testimony that you were not hired to test the specific scenario of a deer running in front of the road?
Asked and answered.
You may be heard, Your Honor.
Go ahead.
Witness has not answered the question.
Your Honor, if I may,
Go ahead.
he did answer the question. He said yes, but not solely a deer. That's the direct answer to his question.
Same.
Your Honor. We'll move on, Mr. Roman. Now, you mentioned before that you believe the most likely cause of this accident was a deer, right?
Yes, I believe the most likely cause of this accident was the car making an invasive maneuver off the east bank of the road to avoid striking a deer in this highly forest populated area.
So with a simple yes or no, Mr. Roman, you believe that the cause of this accident was a deer, isn't that right?
I believe the most likely cause was a deer.
In fact, in the demonstration you brought to court today, you specifically stated that the vehicle swerves to avoid the deer and exits the right side of the roadway. Isn't that right?
Objection, Your Honor. During direct examination, opposing counsel objected to these statements as hearsay, and moving forward in the direct examination, we never referenced these statements whatsoever. So to bring them up now would be hearsay as well.
Maybe you're Your Honor.
Sure.
I'm not saying that the witness made a statement, but the witness brought this demonstrative, and the demonstrative is making a statement. That statement is being asserted for the truth of the matter asserted. Regardless, right now we're not arguing hearsay. I'm just asking the witness whether or not this sign, his sign says that.
Overruled.
So, Mr. Roman, it states that a vehicle swerves to avoid a deer and exits the right side of the roadway, right?
That's correct.
Now, Mr. Roman, you remember making an affidavit for today's case, isn't that right?
That's correct.
And you'd be able to recognize it if you saw it, right?
Yes, I would.
Motion to approach opposing counsel, Your Honor?
Yes.
Motion to approach the witness, Your Honor.
Yes.
Mr. Roman, is this your affidavit?
Yes, it is.
Is that your signature on the back?
It is.
You're aware that you could have changed anything in this document moments before entering court today.
Yes.
And you were aware that you were under oath of perjury when you made this affidavit. Is isn't that right?
That is correct.
So you wouldn't lie on this affidavit, isn't that right?
No, we're not.
Now, Mr. Roman, I'd like to direct your attention to line 37 through 38 of this document. Why don't you go ahead and read silently as I read aloud. I am in no position, based on the evidence available, to determine conclusively whether a deer in fact run in front of Dawson's car immediately prior to the accident. Did I read that correctly?
That's correct. The most likely cause, though, was a deer.
No. Your Honor, motion to strike all the testimony relating to the specific fact that there was a deer in the roadway that night from previous direct examination.
Your Honor, yes, to strike the testimony that there wasn't. At no time this would say, or in fact, conclusively, there was a deer in the road. All of his testimony was about what the most probable cause of the accident was.
Motion to strike is denied.
May I be heard, Your Honor? The witness did testify to saying that the cause of the accident was a deer. The witness testified that the area is heavily populated with deer. If we let this testimony in, it's going to be highly prejudicial to the jury. When we just heard the witness just say.
Actually, the witness didn't say that the cause of the accident was a deer. He did say it was likely. So the motion is denied.
Motion to retrieve the document, Your Honor?
You may.
So, Mr. Roman, you conducted an investigation, right?
Yes, in my investigation found the most likely cause of the accident.
Objection, Your Honor, non-responsive.
Your Honor, maybe we just be allowed to finish this answer.
Your objection is granted.
Motion to strike everything after yes, Your Honor.
Granted.
So you did conduct a report, Mr. Roman. You were paid $5,000 to conduct the report, isn't that right?
Objection, Levins.
Isn't that
I
right?
was paid $5,000 for our services.
$200 for 25 hours worth of work, isn't that right?
That's correct. So I firm operator. We had to pay invoice.
In fact, you were paid $2,000 just to testify today, right?
Yes, that's correct.
So based on your rate, you would say you do comprehensive work, right?
Excuse me?
Based on that rate, you would say you do comprehensive work, don't you?
Our firm does comprehensive work. We do thorough investigations.
Okay, so like you just mentioned, you said you would do a thorough investigation, and you would have included everything relevant in that report, isn't that right?
That's correct.
Now, Mr. Roman, when you testified earlier that there was rutting on the side of the road, right? Those are vehicle tire impressions, right?
That's correct.
And that was what led you to conclude that the defendant made an evasive maneuver based on the angle, isn't that right?
That's correct.
Now, Mr. Roman, you took pictures and you included them in your report, didn't you?
That's correct.
In fact, you took 2 pictures of the vehicle, isn't that right?
That's correct.
2 pictures of the road,
That is correct.
2 pictures of the crash site itself,
We did.
1 picture of the slope,
That is correct.
but no picture of